accident cases, what you should know. If you have been involved in a car accident and you think another driver is at fault, you may want to take your claim to court. Alternatively, you may wish to hire a lawyer to help uncover evidence or to speak to the other driver's insurance company on your behalf. Below you will find links to articles that may help you with all of your queries and questions. Starting a car accident lawsuit. If you have been involved in a car accident and your insurance company or that of another driver did not resolve the case quickly, you may need to file a lawsuit. If you would like your settlement to be more than your state's small claims court limit, you will need to start a pre-trial process. Your case will need to be filed in a civil court, and you will probably need to hire a personal injury lawyer to help you. Starting your case. Filing the initial document. You will be required to file an initial document that's known as a complaint. This document includes everything about the case that you're making, and who you're making it against. In the complaint, you will identify everyone who is involved and state all of the facts that are the basis of your allegations. You will then lay out and explain each element in your claim. Every claim that you make will be known as a cause of action, and you may wish to bring about different causes of action as a result of the other driver's negligence, and for any pain and suffering you have experienced as a result of the accident. In your complaint, you will also need to specify a sum of money that you would like to receive as compensation for all the damages. Had a car accident? What you should know about civil court trials. If you were involved in a car accident and your lawsuit has gone through the pre-trial stage, you may be faced with a trial. This is especially so if no settlement has been agreed upon. Although car accident cases rarely go to trial, it does happen from time to time. So let's take a look at what is involved in a civil court trial. The jury selection. Jury selection will begin and all potential jurors are sworn in. The judge will tell the jury what the case is about and the selection of jury members will take place. It is likely that the jurors will be informed of who you are. At this stage, the potential jurors are asked questions. This stage is known as voir dire, and the judge is the one asking the questions. The questions the jurors are asked are typically based on any issues that the lawyers for each side, the plaintiff's and the defendant's side. If at this stage it is found that a juror is unable to be fair, they will be excused. Using the information that the judge has learned through voir dire, and through the information that they have about each of the jurors, your lawyer can excuse, or strike, some jurors for no reason. Your lawyer does not have to tell the court why he or she chose to excuse the potential juror. Car accident cases and not paying attention. A lot of car accidents are caused by the driver not paying enough attention to the road. This lack of attention is also known as cognitive distraction. The inattention of a driver can be very dangerous, and it's considered to be just as dangerous as drink driving. This is because the driver simply does not pay enough attention to the road. When you pay attention to the road, you can see exactly what is in front of you, what's behind you, and what is on either side. If you fail to pay enough attention to the road, it's likely that you'll be found negligent for any accident you caused. Car accident cases and proximate cause. If you have been involved in a car accident and you've heard the term proximate cause used, you may be wondering what it means. This phrase refers to the act or the failure to act that led to the accident occurring, and any injuries that were sustained as a result of the accident. Although not everyone is aware of what proximate cause is, it may be something that your lawyer may discuss when they are discussing fault and liability for the accident. Cause in fact. You should be aware that a car accident may have proximate cause and a cause in fact, and they are not the same. For example, if a vehicle that was being driven next to yours swerves into the lane you were driving in, the vehicle involved is the cause in fact and the proximate cause of your accident and any subsequent injuries. If an insurance claim were to arise out of the accident, it's likely that the driver of the swerving car would be held liable. If the driver of the car had not acted negligently and swerved their car, it's likely that you would not have been injured. This is known as proximate cause. The negligent operation of the other driver's vehicle resulted in you having injuries. This is known as the cause in fact. However, if someone stepped into the road, and the other driver swerved to avoid hitting them and subsequently hit you, the pedestrian's actions would be known as the proximate cause. Why car accident cases very rarely go to trial. Car accident lawyers and insurance companies generally tend to avoid going to court as they really don't want to be questioned in court or to speak in front of a jury or a judge. In most cases, neither side will want to go to trial unless there's nothing they can do to avoid it. This is because it can be hard to determine what a jury may do, as they can be quite unpredictable. Some juries may believe that insurance companies try to get money out of people, whereas others may believe that the plaintiff, the person who was injured in the accident, is only in it for the money. Insurance companies also tend to have the view that one jury in one state or city may come to a different conclusion than a jury in another state or city. This is just one of the reasons why insurance companies do not like juries.